o'clock, so I think it's perfect to go ahead and call the April meeting of the if we could start with a roll, with the roll call being taken, please.
Patricia Williams.
Present.
Jamie Rowe.
Present.
James Corcoran.
Present.
Ashley Williams.
Present.
Cecil Anderson. Cecil Anderson.
I think he's muted.
Present. Sorry about that.
Terry Kerr.
Present.
David Harden.
Present.
Rebecca Longmire is out. Bob Dykes.
Present.
8 members present.
Now if we could recite the Pledge of Allegiance. Ms. Kerr, could you lead us in that? And I think it might be easier if most of us turn our microphones off, just because there ends up being a lot of echo.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, I'm getting some signals that my internet's a little bit unstable, so if at some point, if you all stop hearing me, please wave and get my attention if I cut out. Okay, members of the Board of Zoning Appeals are volunteers from each county commission district. We do not receive compensation for our work on this board and training that we attend. As a quasi-judicial body, we avoid ex parte conversations and conduct our business in accordance with the Open Meetings Act. I'm the chairperson, James Corcoran. With us, we have, I believe, Myers Morton from the Law Director's Office. If the folks who are present from Knox County government could introduce themselves.
Yes, you have representing Knox County Code, Steve Elliott. I'm the Director of Development Services, Kelly Vaughn, Kim Jernigan, and Tammy Harvey present. And
Thank you. Let's see. Our voting procedure requires 5 positive votes for a motion to be approved, regardless of the number of members that are present. Today we have 8 members present out of the 9. The first matter would be to, well, I guess let me back up. I think we are meeting electronically again, presumably for the last time, based on the most recent executive orders by Governor Lee. I think we're required to make a determination that meeting in this fashion is necessary for the health, safety, and well-being of our community. I think if, based on the fact that we've already previously done this, I don't think we would need a whole lot of discussion. Certainly, I think from news reports, it looks like things are improving, especially with the availability of vaccines and everything. I'm very excited about that. And I think it'd be appropriate if we go ahead and do a roll call vote to approve the necessity of us having this meeting electronically for April. So if we could have a roll call vote, please.
Patricia Williams.
You said to approve it.
Correct.
Aye.
Jamie Rowe.
Aye.
James Corcoran.
Aye.
Ashley Williams.
Aye.
Cecil Anderson.
Aye.
Terry Kerr.
Aye.
David Harden.
Aye.
Rebecca Longmire is out, and Bob Dykes.
Aye.
Okay, so that's 8 members voting affirmatively. The next matter would be the approval of the minutes from the prior meeting. If I could have a motion to, or if there needs to be any discussion or a motion.
A motion to approve.
Sorry, it froze up a little bit. Did anyone make a motion?
I did. I motion to approve.
I second.
Mr. Chairman, pardon me,
Yes.
Myers Moore, Law Director's Office. I have, from the minutes that you're approving, that I have the 3 orders that we've circulated, that people have commented and edited. And so these will be included in your minutes that everyone's seen. I expect this to be the last time, but I'm about to come to your office when you're there and get your signature on these 3 orders to make sure they end up in the minutes. After today, after no more Zoom meetings, this will be much easier with everybody present. Thank you.
Sure. So we're voting to approve the minutes, including the orders from which I guess I'll be signing the orders. So if we could go ahead and do the roll call vote, Beth, please.
Excuse me, who seconded the motion to approve the minutes?
I believe that was Mr. Williams.
Williams.
Thank you. Patricia Williams.
Aye.
Patricia Williams votes aye. Jamie Rowe.
Aye.
Jamie Rowe votes aye. James Corcoran.
Aye.
James Corcoran votes aye. Ashley Williams.
Aye.
Ashley Williams votes aye. Cecil Anderson.
Uh,
Cecil Anderson votes aye. Terry Kerr.
Aye.
Terry Kerr votes aye. David Harden.
aye.
David Harden votes aye. Rebecca Longmire is out. And Bob Dykes.
Aye.
Bob Dykes votes aye. All members present voting aye.
So that motion carries. The Knox County Board of Zoning Appeals is authorized to grant variances and hear other matters by Tennessee law and Knox County zoning ordinance. Specifically, these laws prescribe parameters required to grant a variance. The burden of proving the grounds for variance rests upon each applicant. For each matter, the clerk will read the request into the record. I'll then ask if the applicant is present, and then ask if there's any opposition or other speakers who wish to present. You don't have to come forward at this time, but just if you could identify the fact that you're present. Once we determine the speakers for each item, we will call on the governmental agencies such as Planning Commission, Knox County Codes, or Engineering to make statements regarding the facts pertinent to the property and background of the request. Board members may ask some questions of the governmental agencies at that time once they've made their statements. Then I will call on the applicant to come forward, state their name and address for the record, and present their evidence and reasons supporting the granting of the variance. If there's no opposition, applicants get 10 minutes. If there is opposition, each side gets 15 minutes. After the presentation of the applicant, board members may ask questions. We'll then call for the opposition or any other parties who would then have 15 minutes. And after that time, they may be asked questions of the members of the board. Finally, once both those time periods have run, there will be discussion of the case by the board, during which time commissioners may ask further questions or hear further proof, and then make any motions for determinations the board deems necessary. Our bylaws do allow an applicant at the initial hearing matter to request a deferral of 30 days or 60 days without prejudice. In the event of a deferral of an application or failure to appear, any opponents that wish to be heard on the record at that meeting may present at that time. If we could have the representative of the law director's office swear in anyone who intends to speak.
If anybody that's going to testify, please raise your right hand and repeat after me. You swear to tell the whole truth and nothing but the truth, so help you God.
I do.
Thank you. That's it.
Thank you, Mr. Law Director. Do we have any agenda changes or corrections to make, or any deferred items? I don't believe we had any from the agenda review meeting.
Yes, Mr. Chairman, the codes office has an affidavit for item 4A that was submitted to us late. We will get it as part of the official record, but I wanted to read that into record before we got started. It is the adjacent property owner to the west of the church. And the affidavit reads, I have had a conversation with Wendell Connor from Atkins Baptist Church. I understand there's a property line issue concerning their building project. To whomever it may concern, I give my consent for Atkins to build as close to our property line as needed. Sincerely, Eddie Claude Hickman, and it is notarized.
Thank you. Then let's go ahead and start with item 4A, if that matter could be read into the record by the clerk's office, please.
Request of Atkins Baptist Church for variance of the Knox County Board of Zoning Appeals for waiver of the side yard setback from 35 feet to 11.8 feet. Property located at 6115 Tazewell Pike, CLT map 039, Group DB, parcel 006, property zone agricultural in the 8th Commission District.
And codes, I assume everything you just said that affidavit is applying to this item 4A.
Yes, that's correct.
If you want to go ahead and provide us with a quick rundown of the facts of this matter, please.
Yes, the property is zoned ag, and at the back of the packet we provided, it talks about the side yard setbacks for churches in the ag zone. And it says the side yard setback shall not be a distance less than 35 feet. So in this case, the church is requesting a setback of 11.8 feet. There are two existing structures on the parcel that were in existence at the time of the zoning ordinance that do not meet the 35-foot setback. But it is my office's interpretation that any new structures would have to meet the current setback. So other than that, our office doesn't have any issues with the setbacks.
Quick follow-up question for codes. One thing I'd like to make sure of, especially when we're dealing with anything potentially regarding religious freedoms being restricted. If this was any other type of other building, accessory building, or something that's not a dwelling, something that's religion neutral, would the same setback apply?
I think the section specifically says churches and other main and accessory buildings other than dwellings and building accessories to the dwelling. So if the church had a dwelling that, say, a home the pastor lived in, it would not have to meet the 35-foot setback. Only the main building or accessory to the main building would have to meet the 35-foot setback.
So the important part is that this isn't a dwelling, rather than that it is, or rather than it's a church or something, religious centered.
Yes.
Okay.
That's correct.
Thank you. Does anyone other member of the board have any questions for codes before we proceed to the applicant? Okay. Seeing none. Who is present on behalf of the applicant?
I think Mr. Williams has his hand up.
Oh, Mr. Williams. Before we get to the applicant, Mr. Williams, please.
I apologize. Can I get some clarification? It says the reason to add a small addition onto the church. Is this in fact an addition to the existing structure or a new structure in entirety?
It is a new structure. In your packet, there is a there is a site plan that kind of shows the proposed building. There was no attachment to the existing that we were aware of. As you can see, there's a concrete pad there. There's an existing concrete pad, and then they're building this structure, kind of attaching to that concrete pad off the back of the existing structure. Can you share that aerial, Kelly? We're going to screen share with you the aerial of the existing facility.
You want the site plan or the aerial?
The aerial from KGIS. Looks like this structure will go on that existing concrete pad there.
Thank you.
For clarification, if it were to be attached, they would not need a variance. They only need the variance because it is a detached structure.
All right, does that address your question?
Yes,
Looks
thank
like
you very
I'm
much.
freezing up. Can anyone hear me?
Yes.
Okay, I froze up for a minute there. Is someone here on behalf of the applicant? I know I've had some.
Mr. Jenkins or Mr. Cooper, that was the applicants. Are you guys present?
Mr. Cooper
looks
is
like-
here. He seems, Mr. Cooper is on mute, it looks like.
On the off chance, if y'all are new to Zoom, there's a mute button that's probably in the bottom left corner. And so right now,
Okay, this is
no one can hear you
Mr.
if
Cooper.
you're
Can you
talking.
hear me?
Oh, there we go.
Okay. This is Mr. Cooper. I'm the pastor of the church.
Oh, all righty. And actually, I should probably ask this: is anyone here in opposition to this matter? Okay, not hearing any. Mr. Cooper, you'll have 10 minutes to present. Of course, if you don't need that full amount of time, you don't have to take it up just because you got it. If you just want to kind of give us a quick rundown of the reasons for the application, please go ahead and do so.
Okay, it is an addition to the fellowship hall. We have grown pretty good the last year and before COVID, and we'd outgrown the fellowship hall. We didn't have enough seating, so we simply needed to add like 4,000 square feet and move it back and give us more room for the fellowship hall. That's all it is.
And maybe perhaps you can help clarify a question that Mr. Williams had earlier. Is this all going to be one contiguous building, or is this a separate building that's going in behind
Well,
the
the fellowship hall is separate now from the church. There's a little space in between there. You can't really see it much from this aerial view, but it is separate. And this building will be connected to the fellowship hall. It will not be a new separate building. It will be one continuous building for the fellowship hall.
So you're literally building onto one of the buildings that's currently physically present there right now.
Yes, that is correct.
I guess the question I would have for codes is, does that change the analysis here?
It sure does. The site plan provided shows a separate structure. It doesn't show a connection, and I'm pretty sure we specifically asked that question if it was connected or not, and we were told it was not. So if it is connected, they would not need a variance. They could add on to the existing structure. That they just can't make the condition worse. So they couldn't get any closer than what the existing structure is, but it looks like the existing one's on the property line as is. So,
well, actually, it's not. I don't know what's happened to the map, but it's right now. It's like 10 feet 8 inches off of the property line. We're moving it a foot over just to give us a little more room back there. But it is going to be connected to the existing fellowship hall.
then there's no variance needed.
Okay.
Is
Thank
it?
Just to make sure we're all on the same. Just make sure we're on the same frame of mind. Meaning it's going to have the same roof.
The roofs will be connected. Yes, we will make the roofs join.
Okay.
Yeah. Okay. I'm sorry for this. We asked and we were told it was two separate structures. So my office's apologies for even putting this on the agenda.
Okay.
So, Mr. Law Director, perhaps you can correct me if I'm wrong, but it sounds like in this circumstance, the appropriate thing would just be to dismiss the application just because it's really kind of moot.
Yes, that'd be appropriate. And I don't know that we need an order that says otherwise.
Will we need to go through the formality of a roll call vote on this? Mr. Law Director? I- If the law director's speaking, I can't hear him, although maybe I'm frozen.
No, I can hear you, James.
I'm sorry, Mr. Chairman, codes enforcement's trying to review the circumstances and make sure a variance is not necessary. Can we have about just a couple of minutes?
Sure. We'll take a quick time out. Ms. Kerr, is your hand up?
I'm
Nope.
trying to put my hand up, but I keep clapping.
It looks like a hand and now it's a thumb.
I know, I'm doing the wrong thing.
You
Oh,
hitchhiking?
so I had a question. I did want to try to, what was he talking about? Something, Mr. Cooper, you said it will be attached, but did you say you were moving the existing building?
No.
I
We're
got
just
a little-
adding to it.
Okay, what were you talking about moving something? When we were asking about you being up against the lot line, you said you were off, but you were going to be moving it.
We're moving it 1 foot, would be to the east off
Okay,
of that left side, which gives it, there's actually a driveway down through there. And that gives us a little more room for the cars to get down through there.
okay. So I guess a question for codes would be, it's okay that it's being moved. That's not an issue then, is that correct?
That's correct.
Okay.
They can build onto it if
Okay.
it's connected.
Well, yeah, it is connected.
I think we should withdraw this and we can handle this here. Mr. Cooper, if you could contact our office, we'll refund your money. And again, I apologize for the confusion. We thought it was 2 separate buildings, that they were building a completely new structure. So there would be no variance needed to add on to this existing structure.
Okay, thank you, sir.
As a result, Mr. Chairman, I advise that the Reverend Cooper just withdraw their application now.
That he requests a withdrawal.
Okay.
Reverend Cooper, are you in agreement to do that since you don't need it?
Yes, I'm in agreement to do that.
Well, yeah, all righty. That sounds absolutely fine. Then I don't think we need a formal vote on that, is what I'm hearing. So I think that'll conclude this matter, and it sounds like pretty amicably. So
Thank you very much.
we appreciate you coming before us, and sorry we had to take up your time on a miscommunication.
That's okay. Thank you all.
All right, you
Great
take care.
day.
Bye-bye.
All righty, then if we could proceed to the next numbered item on the agenda, if the clerk's office could read that into the record, please.
Item 4B is request of Stephen Abbott for variance of the Knox County Board of Zoning Appeals to waiver to allow accessory building to be located between the principal structure and the street. Property is located at 1919 Ritter Lane, CLT map 145, parcel 06516, property zone ag in the 4th Commission District.
Okay, is the applicant present?
Present.
All righty, do we have any opposition present? Okay, I didn't hear any. Okay, so codes, if you could walk us through item 4B real quick, please, I appreciate it.
Yes, the property owner is requesting to place a accessory structure in front of the primary. The property is currently zoned ag, and it is a 5-acre tract. The primary structure is at the back of the parcel, and it's up against the rear setback, or pretty close to the rear setback. So there's no room to put the accessory behind the primary. And they're requesting to put the accessory in the front, and it would meet all the applicable setbacks as well. And I think that's pretty much all that our office would have for that.
Can codes comment at all on the topography of the lot or the shape of the lot?
I think the lot is pretty steep. We'll share a screen here and show you guys the topography of the lot.
Mr. Williams has his hand up.
I was just going to say,
Mr.
while
Williams, while
codes
we're
is,
waiting for them to get that up, are you wanting to address codes prior to the applicant speaking?
not to address codes, just to speak on the lot.
Okay. And codes, were you about to put some photographs up just to make sure I'm not waiting for you unnecessarily?
Yeah, we're pulling them up right now. Here we go. We got them coming.
Okay.
Zoom in a little, Kelly. You see the property's got some pretty steep topography on it. Looks like maybe even a sinkhole, so there may be some sinkhole buffering issues. You know, we may have to get an engineered letter on the footings for the structure, but where's this? Oh no, it's going to go. Yes, right in there is where right where the cursor is where the accessory is going to go.
And just so we're following, can you use the cursor to show where the principal structure is?
Back behind, Kelly. Yeah, right in there, around that 940 contour mark.
Okay. And would code say that the topography and lot shape are unusual for this area?
I would say the topography is probably exceptional on this lot.
All right. Thank you, codes. Mr. Williams, your hand's still up?
Yeah, I drove past there twice on Saturday. If you can zoom out just a little bit, well, you don't need to bring it back up. From where the variance sign is posted on the property, looking down towards the property, or where the structure is going to be, you can't see any of the main structure or the secondary structure. Neither would any neighboring houses. The first 20 feet off the road is somewhat flat, but then it just drops straight down. It's actually, they've done a great job with the placement of the existing structure, the main house. I see no issues in that. That's just my opinion, though.
Mr. Williams, just so I'm following, would you say you said you can't really see anything from the road? Is that because of the topography or because of the vegetation or combination?
Combination. It does drop way down, but it is heavily vegetated, but it's also the main structure and where the secondary structure would be located so far off the road, as well as the curvature of the driveway with the vegetation, you wouldn't be able to see it. You'd have to enter the driveway 40 to 50 feet and then make a right-hand turn to head down towards the structure before you could even see either structure. Does that help?
It certainly helps me. Ms. Rowe, I see your hand is up. Mr. Williams, had you concluded before I proceed to Ms. Rowe? Mr. Williams? Okay. Ms. Rowe, go ahead, please.
I just wondered what the structure was for. Is it to hold farm equipment, mowing equipment, something like that, or?
I'd say that question is probably appropriate for the applicant. Let's go ahead and let the applicant say their piece.
Okay.
I'll come back to you, Ms. Rowe.
Thank you.
Okay, and the applicant, is that Mr. Abbott?
Yes, present.
Okay. If you want to state your name and address for the record, and then just you've got 10 minutes to explain why it's appropriate to grant this variance. Of course, you don't need to use all that time if you don't feel you need it, but you got it.
Certainly. Steve Abbott, 1109 East Woodshire Drive, Knoxville, Tennessee. The side does drop off considerably from the main road. We're 486 feet to the accessory structure. And this is just an accessory garage for boat storage, workshop, etc., to the main dwelling. If they could have put it in, they would have, behind it, but there's just the main house, principal house. There's no way to situate that. And I think some of the topography that the county was seeing, I know those hatchered contours show a depression, but I don't believe there's any sinkholes out there, but I think they would be willing to get a letter to justify that if they need so. And that's all I have.
Is there any plan to reduce the vegetation that would probably be blocking the view from the road?
No, I would think not. I think the owner loves landscaping, so I would say he would probably even landscape it even more so, where it would not be visible until you drive into the main dwelling.
Do you think the property owner would be okay with the restriction that required there to be some form of vegetation that prevented the view, just in whatever form?
I think so, because right now where the accessory is going, there's some, I don't know if they're ornamental evergreen type trees that will be moved and relocated in front of it. So yes, that can be handled.
Ms. Rowe, did what the applicant has said so far, did that answer your question as far as the use of the property?
A little. I just wondered like if it would have any kind of like a tractor or anything like that being stored in it.
Mr. Abbott, do you know the answer to that?
You know, other than, you know, maybe some UTVs that the owner rides around on his property or lawnmowers, I don't think there would be any commercial equipment or anything like that.
I just thought maybe it would fall under the farm building kind of clause within that thing. That's what I was getting at. Thank you.
Yeah, I think what she's getting at for the benefit of the applicant is if it's considered to be an agricultural building, I don't think the same restrictions apply as far as whether or not it can be in front of there. So, but if it's sort of ambiguous, it's probably best for us to figure out if the variance is applicable anyways. Does anyone else from the board have any questions for the applicant? Or seeing none, does any member of the board have any motions to make regarding this property?
I'd make a motion to approve.
Second.
For the benefit of our law director, who's going to come up with the applicable order for this, Mr. Williams, could you maybe flesh out a little bit the reasons for granting the variance in your motion?
Sure. I would move to approve based off of the topography and the distance from the main road and the applicant's willingness to plant shrubbery to hide the structure.
Ms. Williams, do you still second it with that
I
additional
do.
language? All right, thank you. Any further discussion prior to proceeding to a vote? I'm not seeing any hands up, so if we could proceed to a roll call vote, Madam Clerk.
Patricia Williams.
Aye.
Patricia Williams votes aye. Jamie Rowe.
Aye.
Jamie Rowe votes aye. James Corcoran.
Aye.
James Corcoran votes aye. Ashley Williams.
Aye.
Ashley Williams votes aye. Cecil Anderson. Cecil Anderson votes aye. Terry Kerr.
Aye.
Terry Kerr votes aye. David Harden.
Aye.
David Harden votes aye. Rebecca Longmire is out. And Bob Dykes.
Aye.
Bob Dykes votes aye. All members present voting aye.
All right. Accordingly, the variance is granted. And that concludes this matter. Congratulations. All righty. I believe the next matter on the agenda, I think, was put at the request of the law director's office, discussion of the North Shore Corridor appeal. Mr. Law Director, do you want to take the lead on discussing that for that matter?
Okay, the North Shore Court, this is an ongoing case, an old case, and this has to do with the development the developer it's off of Pelsu Parkway, out there on the peninsula. Right where you come in from
Tools
Blunt
Bend.
County.
Tools Bend Road.
Tools Bend Road. And previously, this board of zoning appeals approved the development with certain exceptions. Well, the plaintiff includes an entity, an association called North Shore Corridor and some other individuals. They appealed it. We talked previously in our previous session about how administrative decisions such as this are appealable. They appealed this. It went to circuit court. And while there, they litigated, and the trial court overruled and determined the board, the BZA, this board had made a mistake and was in error in approving this development. And the entire decision is based on one issue. The court, the trial court, interpreted the zoning ordinance as not allowing a wastewater treatment plant to be included in a PR zone. And that's the entire basis of the decision. I mean, there was other things discussion, but that was the basic legal reason to say that this board acted illegally in approving the development because the zoning ordinance did not allow a wastewater treatment plant. Well, the developer and Knox County appealed that trial court decision in circuit court to the Court of Appeals. And the Court of Appeals recently came down with a decision affirming what the trial court did. And it's a 20-something page opinion, but basically it adopted what the trial court said and saying that the trial court had interpreted the zoning ordinances of Knox County and determined that the zoning ordinances never in any situation allowed a wastewater treatment plant in a PR zone. That decision has become final, but there's an appeal that we can ask for permission. The appeal process to the Tennessee Supreme Court, where we say a number of reasons that the decision can be incorrect on the Court of Appeals and the trial court. Frankly, the developer, their attorneys, very capable, very experienced, have drawn up a petition to request this appeal to the Supreme Court. I've been reviewing it. I've made additions and subtractions, and not too many, but basically the problem with what the Court of Appeals does is they have some judges taking your place. And this is the proper venue. This Board of Zoning Appeals is the appropriate venue to decide what the zoning ordinance allows, not judges in a courtroom or in the Court of Appeals. And so what I strongly advise this board to vote to confirm, to vote to instruct the law director's office to participate with the developer on this appeal. I think the trial court and the Court of Appeals made a number of different errors in their decision. I don't want to get into legalese unless asked to with this board, but what I'll do is we've developed and ready to file a petition this week seeking permission to the Supreme Court to appeal it. And it's entirely discretionary to take if the Supreme Court wants to allow it or not. I think it's necessary to do this appeal for a couple of reasons. Historically, cases that are not sought to be appealed to the Supreme Court, the decision of the Court of Appeals is not a reported decision. The only way to get it reported in the books is to appeal it to the Supreme Court, whether the Supreme Court takes it or not. If the Supreme Court decides in their discretion not to take it, then that case becomes final, it becomes reported, and it becomes more influential to this across the state. So I think it's necessary to appeal to the Supreme Court to make this decision more severe and more applicable to all the counties across the state. If we don't appeal it, it's less persuasive. And if they're going to do it to Knox County, they need to do it to every county. That's one way to look at it. Also, I think it's necessary to appeal to the Supreme Court because we understand that there some errors were made in the law. And basically, this board is, our system of governance is set up for this board to decide if a wastewater treatment plant is to be allowed in a PR zone and not the court. So that's where we are. What I'll do is this petition will be shared. I'll email it to everybody. It's in final draft form. There's some work to be done. I have to reiterate the developers' lawyers have done the yeoman's work. They've done most of it. They're going to appeal it with us or without us, but I think it'd be very prudent and necessary for us to join in. And that's the advice of the law director's office. So this board needs to, I think, have a vote and say to participate in this appeal to the Supreme Court. However, at this point, I'll answer any questions anybody has. Thank you, Mr.
The questions that immediately pop into my head is this appeal likely to be made by the developers regardless of our input or involvement?
Absolutely. They're ready to go. They're waiting on me, actually.
Yeah, is our joining or non-joining going to increase the expenditures of the county one way or the other?
At this point, the Court of Appeals and tax cost against us to date, the only, as far as expenditures, if the Supreme Court decides not to take it, they will tax cost to us and the developer again. If the Supreme Court decides to take it, they can still rule in favor of what the Court of Appeals said, but the cost could be taxed to us. But under the circumstances and the law that comes out of this, I think that's an insignificant cost based upon what the law may end up if we don't appeal. But I think the developer will go without us, but we've been with them so far, and I advise we continue ahead because it's altering this board's authority, and I think contrary to what the law provides, that's what we will be arguing. Whether the Supreme Court agrees, we will see. Does that answer your question, Mr. Chairman?
If the I guess the law of the case were to be affirmed or just to remain as it is that case one that's likely to come back in front of us anyways from the property owner? Are they likely to make some changes and file that again in front of the Planning Commission?
Yeah, I understand that the developer has requested that their concept plan be renewed for an extra 2 years in anticipation of this.
That was approved.
And it was approved. So they're, to answer your question, yes. If we lose this appeal and they lose the appeal, I anticipate they will be back in a different form and manner. Yes, sir. If we lose this, if we win it, if the Supreme Court sees it's our way, then we will try to convince the Supreme Court that the law provides that what this board did previously was legal and correct and righteous, actually. And so if that happens, then it's a done deal and they'll have their development. Now, the Supreme Court, one option could send it back and say, do this, that, and this over again, but you just don't know. We'll be arguing that what this board did what they're supposed to have done, and they voted and decided they could do this, and it was correct. So to answer your question finally, if the Supreme Court, if it turns it down, I understand the developer at least has reserved the opportunity to redo it and come back again, because part of this case is, the entire case is based upon a wastewater treatment plant on this development. Since this case was decided before the trial court, the utility, Lenore City, First Utility District, they've already said, fine, they're gonna put in a new wastewater facility and may not even end up on this facility. So it will come back with a development. I do believe that's the impression I get from their attorneys. They want this development. The question is, if the law allows the court to replace this board in making this decision, and that's pretty serious precedent in our advice. So I'm sorry, it's a long answer, and that's what lawyers do. But yes, I think if we don't appeal or if the appeal's lost, they will appear back before us.
Didn't mean to dominate the discussion with all the questions. Any other members of the board have any questions for the law director's office, or any other points that they'd like to make on this topic before we talk about Ms. Rowe?
I would like to, simply because I've followed this case from the beginning, and I wasn't on the Board of Zoning Appeals when they voted on this one, but I thought MPC was wrong, and also the Board of Zoning Appeals was wrong to approve that with a wastewater treatment plant, because I do not see any provision for that within the PR zoning on for a wastewater treatment plant. That's my opinion. I realize we've all got one. And to me, it sets a bad precedent. If they're going to be connected anyway with Lenore City or with First Utility or whatever, then this sets a precedent that in any PR zone, they could have a wastewater treatment plant. And to me, that's a worse precedent than the other. Thank you.
Well, Ms. Rowe, this is Myers Morton again. I think the vote before the BZA at the time was 5-3, so you'd have been voting against it, right? So, I mean, I think the vote was 5-3, where it was approved. So, thank you. That's it.
Yep. That was going to be my next question in terms of how it was voted, because I do recall it was narrow, just barely made it. And in addition, as Commissioner Rose says, if I recall correctly, the wastewater treatment plant wasn't on the plans. And that came up somewhere in conversation in the discussion. And the plans that they presented changed gradually. They added a little this and a little that. And as things became apparent, then they would reveal it. But the treatment plant was discussed, but it was not on the plans they submitted. So it was as though it was being, I felt like it was being hidden or withheld. It seemed to have been somewhat withheld information. So I'm sure I was one of those that voted against it.
Ms. Williams, the initial plan didn't have the wastewater treatment plant. However, subsequently, several did, and it was thoroughly disclosed. MPC approved it, and the Board of Zoning Appeals, I vote approved it. So, yeah, you're correct. In the initial plan, it didn't do it, but I understand development plans evolve based upon what the situation needs. And so you're correct initially, but nothing was hidden, absolutely not. As far as, and I'm reviewing what's in the record on this appeal. So does that answer your question, Ms. Williams?
Yes, thank you.
And okay, I see Mr. Harden, I think, is next, and then Mr. Williams will be after that.
What I remember about it is they literally dumped thousands of pages on our pre-meeting. We had no chance to read any of it at all before the meeting started. And I personally think it was the North Shore Court of Appeal made their case poorly. I think that's why we probably approved it. Because I know I was absolutely furious of the 2,000 dump pages 30 minutes before the meeting. I think that's why, and of course, I think now Mr. Morris has brought up that should have been brought up a week before, and it wasn't. So, you know, I just have a huge problem with it. I would like to move forward with the appeal myself.
Well, I seem to recall both sides presenting a lot of information at the last minute. Oh, that could be said of a few of these. Mr. Williams?
Apologize, I'm getting over bronchitis. This is for the law director. I'm trying to figure out if I need to abstain on this because I do know, excuse me, one of the people on the North Shore Corridor Association. When I joined the BZA, I stopped affiliation and got off of the North Shore Corridor Association's Facebook or what have you, because I kind of felt this would come back, but I just need to be upfront and honest and ask the law director's question of my placement on this. And I hope that makes sense.
Yeah, Mr. Williams, my practical advice is trust your gut. If you think that you have a conflict, then go with it. Is that good enough advice?
Yeah, I don't have a conflict. I just wanted it to be on record. I didn't want any surprises coming up down the road.
I don't think that's, I mean, you said a Facebook friend. I don't know that Facebook, with the full disclosure, is a conflict. No, sir.
Okay, thank you.
Personally, I think I'm Facebook friends with about half of Knox County at this point, so I probably have to conflict on everything. Let's see. Is that your hand up or?
It is. I did just want to clarify that the concept plan that was approved at MPC initially did not have the sewer treatment plant on it, but the sewer treatment plant was on the concept plan that was voted on and approved at MPC. And it was on the plan that was voted on and upheld by the BZA. So, you know, while it wasn't on the initial submittal, as the development plan progressed through the process at MPC, the sewer treatment plant was on there and fully disclosed in the minutes of the meeting and on the case summary.
And Mr. Chairman Myers-Morton, if I may, the question is not whether this board, some members of the board or not, like the idea, like the thought of having a wastewater treatment plant in the PR zone. The question in this case is, who's the proper authority to make these type decisions? This Board of Zoning Appeals or a court or judges? That's the question that's being, basic question that's being, we'll be arguing. Who makes these decisions? That's the question. Okay, thank you.
And I appreciate that. I know personally, I think I feel pretty strongly that our codes and I believe our state law says that the Board of Zoning Appeals are the folks that are supposed to interpret what Knox County Code says. So I think I certainly agree with the assessment from the law director's office. I mean, I think we could go into the minutia of the individual case itself, but you know, I mean, personally, I think I hung my hat a little bit on the fact that if you build a large enough development of any sort, well, as my kids could tell you from that, you know, everyone produces some sort of sewage to overstate the children's book version of it. And I always sort of felt that it was, you know, a large enough development. Some of that stuff's gonna be incidental, but I think at the end of the day, I think it's appropriate for this board, legally speaking, to defend its ability to make decisions about what Knox County ordinances do say or don't say. So I guess I'd be making a motion to join the appeal, or to instruct the law director's office to join the appeal and do it, you know, assert our ability to interpret our own laws. So that would be my motion.
Second.
I'll second. Okay.
I think I heard Mr. Harden first. Do we need to have any further discussion prior to proceeding to a vote? Ms. Rowe?
I'd just like to say one final thing, that when variances are appealed from the Board of Zoning Appeal, they're nearly always overturned. So our decisions are nearly always overturned on a variance. So just wanted to add that when they go to court.
I'm sorry.
No.
Anybody want to respond to that? I'm sorry.
I don't see anyone with their hands up. Ms. Williams, did you want to speak?
Yes, sir, I do.
Go ahead.
While I highly respect the law director's position and the right to defend our position, excuse me, I truly feel that this is just not the case to use as an example to stand behind. This case was really messy, and there were several things done incorrectly, out of order, and improperly. And Mr. Elliott, I really don't recall ever seeing a plan that positioned and put the sewage plant in there. I do remember our conversation and discussion during the meeting and everything. And the last I recall that man saying was, it'll be somewhere up in here. Okay. I never seen plans that had positioned or placed the sewage plant. And I'm just feeling that,
Okay.
It's a public record.
So at any rate, I just don't feel this is a case that we should be standing behind with with the number of problems they have had.
Ms. Williams, this is Myers Morton. The record, as far as the Court of Appeal, the trial court, and the Court of Appeals and the Supreme Court, if we get there, it's going to be clear. This wastewater treatment plant was in the plans when the NPC, this board voted positively for it. There's no question about that. And it was on the NPC too. And it was there before the NPC too. So frankly, at the last minute, they part of this litigation was the developer tried to just remove the wastewater treatment plant from the whole concept plan, but that was too late. The court ruled, the Court of Appeals agreed it. It was water under the bridge. If you're going to have, you can't change it midstream. So I hope that helps, Ms. Williams.
Yes, sir. I appreciate that.
Any further discussion before we proceed to a vote? Seeing none, Madam Clerk, we could proceed to a roll call vote, please.
Patricia Williams.
Nay.
Patricia Williams votes no. Jamie Rowe.
No.
Jamie Rowe votes no. James Corcoran.
Aye.
James Corcoran votes aye. Ashley Williams.
Aye.
Ashley Williams votes aye. Cecil Anderson.
No.
Cecil Anderson votes no. Terry Kerr.
Aye.
Terry Kerr votes aye. David Harden.
Aye.
David Harden votes aye. Rebecca Longmire is out. And Bob Dykes.
Not being involved in this earlier case, I'm inclined to abstain. I understand the bigger issue related to having the BZA have the authority to make the decisions relative to the variances and to the MPC decisions. I think I should abstain.
Bob Dykes abstains from the vote. We have 4 ayes, 3 no, 1 abstain.
I guess the question for the law director's office is, under our rules, is that sufficient for the motion to carry on this topic?
I'm looking, Mr. Chairman.
While he looks, Ms. Kerr, I see that your hand is up.
Yeah, it is. Would you read your, would you either have the motion read again, what your motion is?
To restate it, I guess would be, my motion would be for us to instruct the law director's office to join the application for permission to appeal to the state Supreme Court on the North Shore Corridor matter.
And that's what I thought the motion was. And I think that, I guess my question is for a couple that, and I understand the feelings that this was most definitely a difficult case for us to go through and to hear. But I think this is a kind of a different motion other than whether we're agreeing or disagreeing. Would that not be correct? I mean, is that not correct?
Well, personally, I would say that folks could either agree with the motion or disagree with the motion for a variety of reasons. I do think that, in line with what the law director's office has said, is that this part of it is more about defending our authority to interpret our own ordinances. So
Correct.
That, Knox County BZA should be able to interpret what Knox County's ordinances are, rather than, an intermediate level appellate court that is responsible for all these Tennessee. So
that's what I was just wanting to have reiterated. That was my understanding. So I just wanted to make sure that there may be other reasons.
I don't think by joining or even not joining that you're necessarily taking the side of one party or the other. It's more of the legal principle, I think, involved is really the heart of this vote. Mr. Anderson?
Mr. Chairman, I was on the board when we discussed this and voted, and I was one of the 3 that voted no with the development. I still have a problem with it just because I've still got the master plan that was given to us, as far as, I don't know if y'all can see that, but it did not show the treatment plant, and I had written it in because we did discuss it, and they showed us where it was going to go. But on this master plan that had been given us, it did not show that. And there's 621 homes going into this development on this 2-lane road on Tools Bend. As far as my vote on your motion, I think that I would like to change it to a yes, just because I feel like that the board does need to have the authority to make a decision on variances and things of that nature. So if the clerk would do so, if she would just change my vote to a yes, I would appreciate it.
I have.
Thank you.
Mr. Law Director, is that an acceptable procedure? Can we do it that way? Or do we need to read?
Yes. No, that's, you can change your vote.
Because the vote hasn't been announced yet by the chair.
Oh, well, I guess I hadn't done that. Okay. Could you Madam Clerk, could you double check my math? There was some cutting in and out on my end. I'd like to make sure that.
Okay, the aye votes was James Corcoran, Ashley Williams, Cecil Anderson, changed to aye, Terry Kerr, aye, David Harden, aye. The no votes was Patricia Williams, Jamie Rowe, abstain was Bob Dykes. So it's 5 aye, 2 no, 1 pass, 1 absent.
So accordingly, the motion would pass 5 to 2 to 1, I guess, for lack of a better way to put it. So we would be instructing the law director's office to file for permission or to join that filing for permission to appeal.
Yes, sir.
Okay.
Okay.
I do have one question, if I may.
Go ahead.
Will there be any expense involved with this? Will we be, I think the chairman asked the question earlier about any finances or expenses that might be borne by the city, by the county. So is there going to be any expense in this?
I'm paid a salary, so no, other than what I'm already getting paid. As far as attorney fees, I'll be the only attorney. I mean, there's other attorneys in our office that will give their 2 cents worth, but as far as attorneys, no, absolutely not. The only expense would be if the Supreme Court may decide against us, and sometimes when they decide against you, the loser pays court costs, which typically are less than $5,000 out of 4 or 3. But no, this is all in-house. The law director's office is handling this. And so no, other than possibly getting stuck with court costs that we already hadn't been charged, no ma'am. There'd be no other charges or expenses to the county.
Okay, and there's not filing fees and various other things to this?
The record's already, the Supreme Court's review will be based what was already filed with the trial court. There's no new filings or anything. It's the Supreme Court will review the record and make a decision on whether an error was made below, which we will assert, based on the record as it exists now, or existed at the trial court level.
Okay, thank you.
Thank you.
And Mr. Law Director, since someone's already filed for permission to appeal, there's probably already going to be court costs one way or the other, right?
We've already been charged with half the court costs by the Court of Appeals. In their decision, I emailed you at the very end, costs will be taxed against the developer and us. Already.
Okay.
Thank you.
Yes, ma'am.
All righty. Seeing no further hands up on that item, I think the remaining item on the agenda, item 5B, is regarding in-person meetings. Mr. Law Director, I think we've already talked a little bit about this, but if you want to kind of give us some guidance on what we can or can't do for next month to the best of your knowledge or the best of your ability to predict.
As of midnight tonight, the governor's executive order allowing these Zoom meetings expires. First thing in the morning, I expect to look and see if there's a new order that was entered overnight. I don't have any idea. I don't typically, we've been dealing with these executive orders. We're on like we're getting close to 80. Typically, the governor passes these or signs these into effect by now on the last day, but tomorrow we'll know for sure. I will endeavor to remember to send an email to everyone tomorrow saying there was no renewal of these Zoom meetings. And what will happen next is that we'll get an agenda for the next meeting, and it'll be in person, and Kim will have us a location, and maybe we're back to eating lunch too. I don't know. Does that answer your question, Mr. Chairman?
Doesn't sound like there's a whole lot for us to discuss then. It sounds like the choice is basically being removed from us. a fair statement?
Yes, yes. If,
I think
if the chairman will allow me, there's one other, after we're through with the open meetings, in-person meetings, I had one other. Okay, go ahead.
Hey, Mr. Chairman, I would want to add to the virtual meeting and the meeting in person. There's been several county commissioners inquired in my office of, why are we still meeting virtually? So I think if there is a new order passed, we probably should discuss further in. I think county commissioners want us meeting in person. I think it provides a better service to the public. So if there's a new order signed in, we maybe should have a little further discussion before we decide if we're going to meet virtual or not.
I appreciate that information. Any other members of the board want to be heard on this topic? Ms. Rowe?
Sorry, I'll be very brief. I just wondered about the agenda review. Will it be held in that little tiny room, or will we get to be in the assembly room for that, or how does that work?
Yes, Ms. Rowe, we have a conference room that we're in. It's on the 5th floor. It provides probably a little more space than that room. So we could do agenda review here. I think unless Myers had opposition, maybe if we wanted to continue agenda review, we could maybe do that virtual. Yeah, then you'd have to get here. So
I just wondered where it would be is what I was trying to get at. Is it going to be in the little room where we just met, where we used to meet, or is it going to be downstairs?
Would it be possible?
We can check and find out. We could.
The meetings will be in a small assembly.
The meetings are going to be in the small assembly room, that they wouldn't give us the large assembly. So maybe we could do our agenda review in the small assembly, but we would have to check and verify that the room was open for us to do that.
Okay, thank you.
I would be fine with
We'll
us-
check on that. Send you guys an email.
Whatever room has the most space, I'd be fine with.
Mr. Chairman, are you going to do a motion?
I don't know that this requires a motion unless
Okay.
Mr. Law Director tells me otherwise. I think just by operation of law, I think we're reverting back to in-person meetings. Is my understanding, and unless Myers, you want to speak up and tell me I'm wrong on that.
Well, Mr. Elliott brought up a good question, is if the governor puts in an order in the next 5 minutes or 20 minutes or next 4 hours, it says we can proceed in Zoom electronically. I guess that's something you can address at the next meeting, Mr. Chairman, like you do in your meetings now. You make a determination at the beginning of the meetings that you're going to do it, and that's when you can discuss it. So no, I don't believe you have to have a vote for anything now.
Just reading the tea leaves as you kind of have, I think it would be highly unlikely, and I think we'd probably be creating a problem that isn't likely to manifest. But worst case scenario, if that were to happen, we would have time to notice perhaps a meeting to actually discuss whether or not we were going to have a further electronic meetings. Can we do that if we needed to, if we absolutely?
Yes, sir. Yes, sir.
My thought would be is to avoid unnecessarily voting on an issue that's not likely to come up. Unless anyone feels strongly the contrary, I'm willing to listen, but I would be shocked based on the way that the governor and the local and our county officials have proceeded. I think we would know by now if there was going to be that provision. Okay.
I agree, Mr. Chairman.
All right.
If Mr. Chairman, if you please, there's one other issue I'd briefly like to bring before the board.
Please do. You have the floor.
Okay, and with these new orders that I'm going to be talking to you in a minute about where you are and when I come over there and get your signature on those 3 orders. The process is put those with the minutes that the county clerk, the clerk's office keeps, and at some point the bylaws instruct this board to record these orders in the register of deeds. Now, while the price is anywhere, I didn't check, $20, $30, $40 probably. Who's gonna pay for that? That's my question. Who's gonna take the more of the expense of recording these orders? I don't know that that's, since we're just starting to do this, and this board has instructed me, we are to record these orders, plus the bylaws say we will record these orders. But the bylaws are sort of say both, say that we have to record them, but also the applicant can get a copy and record them. There's no reason to record them twice, but right now the board will be recording them, and the question is, I don't know if it's a budget question or not, but it's $12. Unless it's more than 3 pages or something. Who's gonna pay for this? That's an issue there, out there.
It is. Would that be one that would be appropriately addressed, I don't know, legislatively by our county commission? Perhaps they should be specifying that. That sounds more like a policy decision than a quasi judicial one.
I think you're correct, Mr. Chairman. That's a good point.
Can we put together something on our agenda for us to make a resolution asking the commission to address that?
Yes, Mr. President, Mr. Chairman, yes, sir.
You just gave me a promotion there, I think. I think I saw Mr. Harden's hand up first. Mr. Harden?
Could the recording fees not be added to their fees they're paying for us to review it anyway? If they win, surely they'd be happy to pay $12 to have it official in their record of deeds. Just a thought.
I think that's an option. If they wanted it recorded, my office could get the order, and then when they came up and paid us the $12, then we could go record it for them. That may be the most reasonable option. It could be that we hand the applicant the order and they go down and record it and just pay the register of deeds. I think there's a couple of different pathways forward here.
My response would be the bylaws say they shall be recorded, shall. And so I don't know if we can rely on the applicant to record it, but.
I wasn't suggesting we rely on them. I was suggesting they pay for it.
I think the problem would become, Mr. Harden, if we deny a variance request. I don't think they're going to be inclined to come up here and give us $12 additional to record the order where they were declined. So that may be.
I think what Mr. Harden might have been more getting at is maybe we should ask for $12 more when they're filing
on the front end. Yeah, that would be the only way to get it. On the people that's denied, the people that are granted a variance, they're going to be happy to come up here and pay the $12.
It makes sense to do it on the front end, but I would rather have more direction from our duly elected folks than us unilaterally deciding to take more people's money unless Codes feels that they can make that decision with their inherent authority. But I can't think of an area in the zoning ordinance where I'm given authority to take someone's money specifically. So I'm a little bit reticent to do that myself. Unless the law director can say we've got the authority to set up a rule unilaterally making that decision.
A lot to digest, Mr. Chairman. What was your question? I'm sorry, Mr. Chairman.
Would we have the authority to cast a vote here saying that they've got to pay that $12 up front?
Oh, that's typically fees are ordinance related, aren't they?
Yeah, I don't know that you need a vote now. Maybe it's something we'll put on the agenda for next time, Mr. Chairman, if you please.
That sounds like a good idea. I would like to have some guidance on what our authority would be as far as setting fees. That's new territory for me. I
will research that and report back. Hopefully, I I'll coordinate with Kim and get this, when she sends the agenda out, I'll have some authority attached with it.
That
Next
that
time.
sounds perfect to me.
And
All right.
if I may, before you adjourn, Mr. Chairman,
Yes, please.
can I call your cell phone when we're done to find out where you are and come get these three orders signed?
Absolutely, but time is of the essence.
I'm, as soon as you adjourn, I'm walking out of here.
All right, sounds good. Anyone else? All hearts clear? All righty. Hearing no other matters before the board, we are adjourned.
Bye, everyone.
Everyone have a good